his absence disables their ability to defend themselves effectively. These are very substantial questions, but the court has declined, and when we have sought to appeal their ruling, and the law clearly says we have a right of appeal and uses the mandatory language, shall. The court, through the judge advocate, has declined, and even declined to hear our arguments. We are leaving this place very sad, not able to know whether the court is still going to function or it's the judge advocate, because he has totally hijacked the proceedings.
We maintain, well, our clients insist they are not subject to martial law.
Yes.
It's the reason they have declined to take a plea. We have persistently put across that argument. We have invoked all the relevant laws to back up that argument that our clients are not subject to military law. They are not subject to martial law, and therefore this court has no jurisdiction to try them here. So they have refused to submit to the jurisdiction of this court, and that is the reason they are not taking a plea. And it's one of the reasons we sought for leave. No, actually not leave. It's one of the reasons we had made the application to have a reference to the Constitutional Court, the jurisdiction of this court, including those matters where the Constitutional Court has pronounced itself persistently even after the Kabazukuluka decision. Because every matter that has gone to the Constitutional Court, the verdict has been the same. The pronouncement has, and it is self-executing. We get a shock of our life when the prosecution said, we need an order of enforcement, of execution. When indeed the constitutional pronouncement or pronouncements of the Constitutional Court are self-executing. So it's we still maintain our clients are not subject to martial law, and this tribunal has no jurisdiction over them, and they will not take a plea before them. That's exactly what has happened today.
We hope that was
the right for one to say, I'm declining to take a plea.
No,
and it's up to them to record whatever plea they want, whether it's a plea of guilty or not. But in law, once one declines to take a plea, they are obliged to do to record a plea of not guilty.
But they should also record that our clients refused to take plea. Therefore, the court has entered a plea of not guilty. So we are hoping that the registry will keep accurate records. The registry which the judge advocate tells us he is in charge.
Bakiriyansi baffe bawakanya obuyinza bwa kooti eno okubawozesa. Mu nsonga nnyingi zonna zetayinza kuddamu wano. Naye zonna nga mulabye nti kooti eno terina buyinza kuwozesa misango gye bagamba nti gyazzibwa Kenya oba Greece oba Geneva. N'okuba nti babaleeta nga tebayise mateeka amatuufu ag'extradition. N'okuba nti nno kooti eno terina buyinza ku ba civilian. Ekintu kooti etaputa ssemateeka kyezeddamu enkya n'eggulo entakera n'emisango gyonna ne tugireeta wano. N'ekitwewunyisizza buli application gye tuteekayo dismissed. Buli ke muteekayo tukagobye. So buli kye tuleeta bagoba bugobi. Awo naakula etteeka ssemateeka kirambika bulungi atuke w'ekikumi nti singa oli pate emu bw'ebeesabye nti ensonga zino zigende mu kooti etaputa ssemateeka, ono bano tebalina buyinza buzigaana na zitaputa, balina buyinza buziframinga. Naye mulabye amenye ssemateeka y'ennyingo '37 ye n'agamba nti tagenda kuziwaayo, aganye. Ekyokubiri, akawaayiro 225 aka UPDF Act kagamba nti atamatidde na nsala ye mu nsonga zonna n'engeri proceedings ezitambulamu oba omusango gye baguddukanyamu waddembe okwekubira endulu mu kooti esingawo. Ekyo nakyo agambye nakyo tuganye. Obuyinza nga judge advocate yalagira nga senior counsel wabagambye nti judge advocate nga akomandinga bukomandinzi kakati ye yefudde amateeka. So judge advocate yeteeka kyalagira ye kati biragiro. So n'olw'ensonga eyo kiranti waffe ye ono bakiranti baffe insisting nti tebalina bakiranti baffe insisting nti kooti eno tebalinaako buyinza era kooti teyinza bagaana kugenda mu kooti etaputa ssemateeka, teyinza bagaana kujulira. N'olw'ensonga eyo era ne bagaa tebagenda kuteekinga puli, bo bali ne basalawo nga bwe basazeewo nti bawandiika ekyo. Neffe kye tugamba nti balina okukiteeka mu rekodi, kukikapukyalinga bulungi mu rekodi mu biwandiiko nti bakirantisi baffe bagaanye okuteekinga puli olw'ensonga nti tebakkiriziza mu kooti eno okubawozesa, teyina buyinza, teyina buyinza bwonna mu mateeka kubawozesa, era ebawozesa mu bukyamu, ebakaka bukasi okubeera mu kaguli n'okubawozesa. So n'olw'ensonga eyo tugenda kusala tulina enkola endala gye tugenda okulaba bwe tukikolako. Titutudde kyetwagala obbakakasa titugenda kuba nga tuddayo nga legal team, tugenda kutuula ate era tutakule emitwe era tubikkule amateeka amalala. Bwe baziba lino ekkubo nga ate tukwata eddala, bwe baggala lino nga tukwata eddala paka lwe tunaafuna obwenkanya.
That questions are fit for reference to the Constitutional Court. Mr. Chairman, a judicial officer to choose themselves. Regarding issue number 1, it deals with whether the offense under offenses relating to security, section 128 F of the UPDF Act defines the offense. Mr. Kalibala said that it does not define the offense, together with Mr. Mpanga, and their view is that because it says a person who omits or does an act. When you cross-reference with other laws, an offense can be constituted by an omission. It can also be constituted by an act. Even in the Penal Code, an unlawful act or an unlawful omission can constitute an offense. There is also a requirement in the offense that the intent must be to prejudice the security of the defense forces. Those are matters once alleged that are supposed to be subject of evidence, and the burden is on the state. But at the moment, this issue is premature. It is determined with evidence, and this court can decide that matter. There's also an issue regarding whether the trial of civilians in general court martial is consistent with the decisions of civil courts in earlier cases. And one of the cases cited is the case of Honorable Michael Kawaziguruka versus the Attorney General. Most other cases cited, including retired Captain Amoni Byarugaba and Semuju Abdu Minana, we are referring to that decision of the Constitutional Court. But the decision is pending before the Supreme Court, and the orders and declarations made in that decision were stayed. So it would not be an authority that determines the position. We would rely on earlier authorities. The earlier authorities included the case of Hadija Namugerwa versus Attorney General, Civil Appeal number 4 of 2012, where they said the provisions of section 119, which is now 117 of the UPDF Act, is proper, and charges can be maintained under that provision. There is also an issue number 7, whether the General Court Martial has jurisdiction to deal with cases under the Firearms Act. The UPDF Act defines a service offense to include offenses under the Act and those under any other act for the time being in force committed by a person while subject to military law. And the Supreme Court has pronounced on this in Attorney General versus Uganda Law Society, page 10. And in that case, it was a unanimous decision of the Supreme Court arising from a constitutional appeal. They only required that for an offense under an act other than the UPDF Act to be within the jurisdiction of the General Court Martial, it must have been committed by a person subject to military law. And what they required was to allege and show that the accused persons committed either of the two offenses while they were subject to military law. That is the link they require. And the applicants have not shown that that link is not in the charge sheet, and it is the burden on them to show that there is no link. It is not alleged that these people were subject to military law. We also wish to point out that there are procedural safeguards for the trial of persons before the court, including presumption of innocence, burden of proof, and these are matters for a trial court. These are not matters that require constitutional interpretation. With that, I hand over to my colleagues to continue.
Land friend, Captain Ambrose. I'll begin by quoting Article 132, Clause 4 of the Constitution. It says that the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. My Lord, the Supreme Court has severally decided that these courts have jurisdiction to try the accused persons. And my land colleagues on the other side, repeatedly citing the decisions of the Constitutional Court, would be in contravention of that specific article. My Lord, I will reply to the other general issues, specifically on Regulation 63, Regulation 2, and Regulation 69. My Lord Chairman, the General Court Martial operates under a framework of the UPDF Act, which ensures its independence. The Act provides a clear separation between the administrative functions of the High Command and the judicial functions of the General Court Martial. My Lord, I refer you to Section 14 of the UPDF Act, Cap 330, and Section 195, so and establishes the General Court Martial. While the High Command may oversee the general military administration, it does not interfere with the judicial making process of the General Court Martial. Members of this court, including its chairman, are carefully selected and sworn to administer justice without fear or prejudice. Although this is under Regulation 14 of the Uganda People's Defense Forces regulations. They are guided by the principles of fairness and impartiality enshrined in the Constitution, Article 28, and the UPDF Act. The presence of the legal officers and adherence to established legal procedures further guarantees impartiality of the proceedings. This court has autonomy in its decision-making process. It conducts trials based on evidence, law, and legal principles, not directives from the High Command. The decisions rendered, furthermore, the decisions rendered are subject to appeal and review by superior courts. By superior courts, I mean the Court Martial Appeal Court. This is provided under Section 225 of the UPDF Act. The relationship between the GCM and the High Command is administrative, not judicial. The High Command's involvement ensures logistical and institutional support for the court martial, but does not extend to influencing judicial outcomes. Now, concerning Regulation 63, Regulation 2, it is very clear the role of the judge advocate is to advise court on matters law. If the court disagrees with the decision, they shall record in the proceedings in its reasons. It does not mean that they are entirely binding, as one of the colleagues on the other side alluded to. My Lord, I give way to my other colleague to submit. That is all.
Arrest, rendition, and trial of formerly two accused persons, that is Colonel retired Dr. Tiza Besije and Haj Obeidul Taleh. Madam Chairman and honorable court members, the ruling that was rendered by this court today morning settled that. And in that ruling, the court clearly pronounced itself in as far as the arrangement that is between the two countries, that is Kenya and Uganda. And my Lord Chairman, that arrangement is backed by the law. It's backed by the East African Community Treaty, of which Uganda is a party. Not only being a party, but it also domesticated that treaty. And the same thing with domestication was done by our neighbors, that is Kenya, also domesticated that treaty. So, Madam Chairman, under that treaty, specifically under Article 124, that addresses the protocol of peace on peace and security. And the article outlines the commitment of partner states to cooperate on issues related to peace and security. And my chairman to into motion or to put into practice that cooperation. That's when we see the coming up of that memorandum of understanding for the two states to cooperate on matters relating to security and cross-border crimes. Therefore, we also refer to this court the authority that my brother and senior colleague, Councillor Kwago, alluded to, the one of Amar, Awad, Omar, and 10 others. And my Lord Chairman, that's a very good authority, because it clearly highlights the role of states that are parties to the East African Community Treaty. Under paragraph 30, if I may read verbatim, states that we also observe that East African Community Treaty was domesticated in Kenya, Tanzania, and Uganda. In Uganda, Parliament enacted the East African Community Treaty Act of 2002 by virtue of statutory instrument number 29 of 2005. The East African Community Act Commencement Instrument 2005. It came into force